murder, beating to the ball. 2 will vacate by operation of law. 3 pleas.
And then number 3 merges.
Yes, and then the rest of them don't.
Right.
Okay.
Yeah.
Ms. Rivers, are you ready?
Yes, I'm ready, Judge. Good afternoon.
Good afternoon. Well, we will get started. This is 20 SC 175773, State versus Damon Warner. Mr. Abate is here for the state. Mr. Warner is here with his attorney, Mr. Katz. Good afternoon to everyone.
Good afternoon, Judge.
Mr. Abate, my understanding is that the state has reached, is this a negotiated plea or non-negotiated?
It's negotiated, Judge.
It's reached a negotiated plea with Mr. Warner. Is that correct, Mr. Katz?
That is, Judge, and we have already turned in the plea paperwork.
Got it right here. We'll cover that. You two are welcome to stay seated right there, or you can be at the podium. I'm neutral on that. As long as the microphone is on, meaning there's a green light on that microphone in front of Mr. Warner, Ms. Rivers will be able to hear you. So so we'll get started. Mr. Warner, in a moment, Mr. Abate is going to put you under oath. He'll have you raise your right hand. You'll swear to tell the truth. And you'll need to tell the truth in response to his questions and mine. We'll both have some questions for you. They're mostly designed to make sure you understand what your rights are if you went to trial, and the fact that you're waiving or giving up those rights by entering a guilty plea in exchange for a sentence that's presumably less than life without parole, which is the most you could get if you went to trial and you were found guilty. During the discussion, I need you to let Mr. Katz or me know if you have questions about anything. If someone says something that, oh, wait, that's not what we talked about, you need to nudge your lawyer so that I can make sure that we make clear on the record whatever the situation was. Okay? Great. Then you'll need to answer the questions out loud rather than just nodding or shaking your head. When you're ready, Mr. Abate.
Thank you, Judge.
Judge,
Mr.
can
Warner.
he take his mask off? Or?
Please.
Okay.
That will make it easier for us to hear what you have to say.
Mr. Warner, if you'll please raise your right hand. You solemnly swear or affirm the testimony you're about to give in the matters pending before this court will be the truth, the whole truth, and nothing but the truth, sir?
Yes.
Okay, you can put your hand down. Now, if you could do me a favor and state your true, correct, and legal name, and try to do it real loud into that microphone so Ms. Rivers, the court reporter, can take everything down correctly.
Damon Warner.
Okay, and Mr. Warner, are you at this time taking or under the influence of any alcohol, drugs, or medicine?
No.
And is there any medication that you take daily or regularly that you have not taken today that would affect your ability to understand why you're here today?
No.
Okay. And sir, could you tell me how old you are and how far have you gone in school?
I'm 22. I finished school like 10th grade.
Okay. And are you able to read, write, and understand the English language, sir?
Yes.
And do you understand that you're charged in indictment number 20 SC 175773 with the following offenses? Count 1, murder. Count 2, felony murder. Counts 3, 4, 5, and 6, all aggravated assault with a deadly weapon charges. Count 7, criminal damage to property in the first degree. And count 8, possession of a firearm in the commission of a felony.
You understand that's what you're charged with?
Yes.
Okay. And sir, do you understand that you have a right to plead either guilty or not guilty to these charges? If you pled not guilty or remain silent, you may receive a jury trial.
You understand, if you pled not guilty, you would have a trial.
Yeah. I understand.
Okay. And prior to this plea, has your attorney, Mr. Katz, had an opportunity to go over what's called the waiver of rights form as to what rights you're waiving?
That form went over that to jail.
Right.
The form we went to over with at the jail. Remember when
Yeah, I
I,
understand. Everything is home.
And when you went over the form, did you put your initials next to each one of the rights that you're waiving?
Yes.
And then on the back of the sheet, the waiver of rights form, did you sign your name that you understood everything that Mr. Katz went over?
Yes.
Okay. And do you have any questions at this time that you'd like to ask your attorney, Mr. Katz, before we move forward?
No.
Okay. And are you satisfied with the services he's provided?
Yes.
Mr. Katz, do you waive formal reading of the indictment,
was so waived.
as well as any and all defects in the indictment, including any with respect to your client, respect to your client's name for the purposes of this plea or hearing?
Yes, we will so waive.
And Mr. Warner, has your attorney advised you of the minimum and maximum sentence for each charge that you're actually pleading guilty to?
Yes.
And did he explain to you as it pertains to count one murder that the negotiated plea or resolution is to reduce that to voluntary manslaughter under OCGA 16-5-2?
Yes.
And did he explain to you that the minimum for voluntary manslaughter is 1 year, the maximum being 20 years?
Yes.
Okay. Did he explain to you for the aggravated assault charges that the minimum is 1 year, the maximum is 20 years?
Yes.
Did he also explain to you that criminal damage to property in the first degree, the minimum is 1 year, the maximum being 10 years?
Yes.
And lastly, in count 8, did he explain to you that possession of a firearm in the commission of a felony, it's 5 years that has to be consecutive, which means a sentence after or in addition to any other years that you receive. And that can be to serve, it can in prison, it can be probated, or it can be suspended.
Yes.
Okay. And do you have any questions about any of the charges that you're actually pleading guilty to here today?
No.
Okay. And do you understand that this is a negotiated resolution? So your attorney, Mr. Katz, and myself, the state, will be recommending a sentence to the court, Judge McBurney, of 30 years to serve. But the court does not necessarily have to follow that recommendation and can sentence you to how he sees fit, meaning he could add additional years to the sentence.
I don't really understand that part.
So I'll pop in here. The negotiations in your case have been between your side, meaning you and Mr. Katz, and the prosecutor, Mr. Abate, and you all have reached an agreement that a plea to the reduced charges for a recommended sentence of 30 years to serve with credit for the time you served is fair. And that's what everyone I just described has agreed to. I was not part of those negotiations. I'm going to hear more about your case from Mr. Abate. I'm going to hear more about you from Mr. Katz, and I'll give you a chance to say anything you want to say. But in the end, I'm not bound by any of this. I may hear some things and say, 30 seems a little high. Maybe it should be 25, or 30 seems a little low. It sounds like there were 3 other people who were shot at, and so maybe it should be 35. I am not bound by the 30. I could go higher, I could go lower, but I and most judges are typically informed by the folks who know a whole lot more about the case and about you. So I will certainly take that into consideration. All Mr. Abate was wanting to make clear on the record is that you're hoping that you get the deal that the district attorney is asking for on your behalf and that your lawyer is asking for on your behalf, but that doesn't control what I do. Understand?
Yes.
Okay.
And do you also understand, Mr. Warner, that this plea may be used to enhance sentencing on other convictions in this jurisdiction, as well as in other jurisdictions, including the federal courts?
Yes.
And do you also understand that if you are not a United States citizen, a guilty plea will affect your immigration status and will result in deportation, regardless of any advice given to you by your attorney or anybody else?
Yes.
Okay. Do you understand that by pleading guilty here today, that you waive any and all defenses?
Yes.
Okay. Do you also understand that by pleading guilty, you're giving up the following rights: the right to trial by jury, the right to remain silent and to not incriminate yourself, the right to confront witnesses against you, the right to the assistance of counsel hired by you or court appointed if you were unable to afford an attorney for the trial of your case, the right to the presumption of innocence, the right to testify on your own behalf and to present other evidence, the right to subpoena witnesses and to compel the production of evidence, the right to have the charges against you proved beyond a reasonable doubt by the state of Georgia, and the right to an appeal if convicted of the charges after trial. Do you understand that you're giving up or waiving all of those rights here today by taking a guilty plea?
Yes.
And Mr. Warner, has anyone forced, threatened, or promised you anything to get you to enter a guilty plea here today?
No.
And is it your decision to waive these rights and enter a guilty plea because you're in fact guilty, sir?
Yes.
Okay. And how do you plead to the charges in indictment number 20 SC 175773, count 1 murder, which is being reduced to voluntary manslaughter under OCGA 165-2?
All right. You guilty?
Okay. And count 2, which is felony murder, which will vacate by operation of law upon the completion of your plea. How do you plead to that?
You guilty?
And how do you plead to count 3, aggravated assault with a deadly weapon?
Guilty?
And count 4, also aggravated assault with a deadly weapon?
Guilty?
Count 5, how do you plead to the additional charge of aggravated assault with a deadly weapon?
Guilty?
And count 6, how do you plead to the last count of aggravated assault with a deadly weapon?
Guilty?
And then do you understand that count 7, criminal damage to property, is being null pros by the state as part of the negotiations with your counsel, means it being dismissed?
Understand?
Okay. And then the last count, how do you plead to count 8, possession of a firearm during the commission of a felony?
Guilty?
Okay. And is this guilty plea freely and voluntarily given with full knowledge of the charges against you, sir?
Yes.
And do you understand that you may only have a limited right to appeal this guilty plea conviction?
Yes.
And then lastly, do you understand that you only have 4 years from today for a felony charge to file what's called a habeas corpus petition challenging this guilty plea?
I
I
don't
have
want
4 years from today's date to challenge this. If for any reason you think I didn't do a good job or something like that, you'd
I
have 4 years.
understand.
Okay. So do you understand that you have only 4 years for today if you wanted to file a habeas corpus petition challenging this guilty plea?
Understand?
Okay. So is that that's a yes?
Yes.
Okay. Your Honor, had this case proceeded to trial, the state would have proved beyond a reasonable doubt that on November 26th of 2019, that the defendant, Mr. Damon Warner, and the deceased victim in this case, Mr. Braxton Bryant, they had been communicating on Instagram after Mr. Warner had posted some stories on his Instagram page of some firearms. At that point, there had been some communication between the defendant and the victim about the victim purchasing a firearm from the defendant, Mr. Warner, throughout the day. Later that evening, Mr. Braxton was at the home of Titus Carter, a friend from high school, actually from elementary school that he had known for quite a number of years. He was hanging out not only with Mr. Carter, but was also hanging out with Tyquan, and I'll spell that for the record, Washington. And it is TY''QUON, Washington, normal spelling. They had been hanging out that evening, just playing video games and things of that nature. Mr. Carter had his girlfriend, Shantia King, which is SHONTIA, who is also the sister of Mr. Washington. She worked nearby at a Kroger, and they had planned to go pick her up. Mr. Braxton or Mr. Bryant knew that and asked on the way back from picking Miss King up if they would just drop him off at his home. After they picked Miss King up, Mr. Bryant had been in communication with Mr. Warner about the sale of the continued communication about the sale of this weapon.
And the sale would have been, the state's theory, Warner selling to Bryant.
That's correct, Your
Okay.
Honor. And after they had picked up Miss King and before taking Mr. Bryant home, he requested if they would stop, which was going to be on the way to Mr. Bryant's house, at a friend's house who he knew as the nickname Squirrel, which the evidence would show that Squirrel is Mr. Demond Warner, and asked if they would stop at his house where he was off a Hart Drive, and so he could pay him some money that he had owed him.
That's what Bryant said to his friends, but it really was to buy the gun?
That's correct.
Okay.
And so Mr. Bryant directed Mr. Carter, who was driving to the location, excuse me, Mr. Washington, who was driving to the location. And once, as they got closer to the arrival, Mr. Bryant called Mr. Warner and said, "We're here, we're close by." And at that point, and that was on speakerphone, at that point, he directed Mr. Washington to pull the car over about or close to the address of 1028 Hart Drive here, Atlanta, Georgia, Fulton County. And as they pulled over, the defendant, Demond Warner, walked up, and behind him were two other individuals who at this time still remain unidentified, I guess, directly to the police. But as the state has continued to investigate, I'm fairly certain I know who the two individuals were. The evidence would show that Mr. Warner approached with Mr. Ziquai, Ziqua Pi, and Mr. Albert Brown. As they approached the vehicle, Mr. Bryant was in the front passenger seat. He rolled the window down, and at that point handed the money to Mr. Warner. And after he handed him the money, he said, "Where's the gun?" And the evidence would show through the three witnesses who were in the car, Mr. Warner just began to shoot at Mr. Bryant. After he began shooting at Mr. Bryant, Mr. Washington floored the vehicle down Hart Drive. As he continued to drive, all three individuals, Mr. Warner and his two friends, began to continue to shoot at the vehicle. Mr. Washington was able to successfully get off of Hart Drive. Mr. Carter immediately called 911 and let them know that Mr. Bryant had been shot. They self-transported to Grady Hospital, and unfortunately at Grady Hospital, Mr. Bryant succumbed from his injuries. At that point, the investigation began. Atlanta police got involved. They were able to speak to Mr. Titus Carter, who positively identified the defendant as the person who walked up to the vehicle and immediately began shooting at the victim and the three people in the car.
Did Mr. Carter know Mr. Warner or knew him as Squirrel, or how was he in a position to identify him? Did the detective, how were their pictures shown?
So Mr. Carter showed him, or excuse me, Detective Lisa Bender showed Mr. Carter a six-pack photo lineup. She was able to actually pull the photo because Mr. Carter was able to describe that the person who shot the victim, he had known as Squirrel, and he had known Squirrel for a very long time because they had all gone to elementary and middle school together. He showed him Instagram, or showed the detective the Instagram profile for Mr. Warner. And from there, she put his photograph in a six-pack photo lineup.
Okay.
And confirmed that the person that Mr. Carter had provided the Instagram profile for was in fact Mr. Warner, AKA Squirrel. The detective was also able, through her investigation, to go to 1028 Hart Drive. She was able to learn that it was an Airbnb. She learned that the Airbnb had been rented by the uncle of Albert Brown. And from there, she was able to speak to Mr. Brown and mostly all of the individuals who were in the house. Specifically, she was able to speak to a Miss Courtney Sr., who was able to confirm that the defendant was at the Airbnb that night, that he had several guns on his person, that he left the house to go do what she believed to be armed robbery disguised as a gun deal. And after she heard shots, the defendant and his friends came back into the Airbnb and spoke about the incident, which she relayed to the police. She further, through a six-pack photograph lineup, also identified Squirrel as Mr. Warner. Had this, that's the evidence the state would have been able to prove beyond a reasonable doubt had this case proceeded to trial. Mr. Warner actually has no felony history. As you heard, he is 22 years old. The only adjudication he has is a burglary from 2016 that was in a juvenile court. Other than that, he has no felony history or any felony, type offenses with the law. The recommendation, Your Honor, is 20 years to serve on the reduced count of voluntary manslaughter, count 1. And then count 2, felony murder, would vacate by operation of law. Count 3, which is the aggravated assault associated with Braxton Bryant, would merge into count 1. Count 4 is the aggravated assault for Mr. Carter. That would be 5 years to serve consecutive to count 1. Counts 5 and 6 would also be 5 years to serve, but they will run concurrent with count 4. And counts 7 would be no pros, the criminal damage to property. And then count 8 would also be 5 years to serve, but it would be consecutive to count 4 for a global resolution of 30 years to serve, all parolable, Your Honor. And nothing further from the state. The state has been in contact with the family of Mr. Bryant. Unfortunately, Mr. Bryant's biological mother, in the time from when this incident occurred and today, she's passed away. We've spoken to the extended family, his grandmother. She was notified and believed the offer to be acceptable, or the resolution to be acceptable. Miss King, Mr. Carter, and Mr. Washington also were all notified, and they all were amenable to the resolution.
Okay. So you're providing effectively the victim impact statement by saying people are at peace with this.
Yes, Your Honor.
Got it. Okay. Thank you. Ms. Harvey, good afternoon. How are you?
Good afternoon, Judge. I'm well. How are you?
I'm good. Do you have any additional criminal history information beyond what we heard from Mr. Abate?
No, Your Honor. That's so.
All right. Well, thank you so much.
You're welcome.
Excuse me, Mr. Katz.
Judge, when you look at these cases, and if I may stand, Mr. Abate and I have talked about this case ad nauseum. I know he's probably gotten tired of me continuously calling him and trying to negotiate this and go whichever way it could go. And I could sit here and what happens a lot of times is when you sit here and try to talk about the facts or what happened or didn't happen, then you end up putting yourself in a trial situation. As Judge Coursey used to say in DeKalb County, well, we might as well just try it, and there are some things that and I think this is what leads to the voluntary situation. For instance, two of the individuals that Mr. Abate has spoken about are actually identified. And I don't know if you're familiar, about a year or two ago, these two individuals were arrested in Far Road in Buckhead for breaking into cars and so forth. Well, in addition, one of the weapons used in this case was found on one of those individuals, and it matched up with ballistics wise. Whether that was in fact a murder weapon or not, we don't know. At the time that they were arrested, Mr. Warner was already in custody.
You're referring to the two people that Mr. Abate has theorized were parties to this, not people in the car, but other people who approached the car.
Yeah, that's Zion Pye or Zion Ty and Albert Brown.
Got it. And those two were the ones arrested on Far Road, one of whom had a gun that matches a gun that fired at least one of the rounds that struck the car.
Correct.
Got it. Okay.
Or may have, we don't know.
May have hit the victim.
May have been the victim. We don't
Right.
know. So you have that. There were issues about, and with all respect to Mr. Abate in the case, there were issues about was there or was there not a struggle at the point that money was being exchanged for the gun? The money, I don't know if ever was exchanged, because it ends up actually being found in the center console where it had been at the point that it was supposed to be exchanged for the gun. Apparently showed the gun once, take it back and said, well, let us look at it again. And there's a question whether it was like grabbing the gun, not paying for it and so forth. In fact, I think it's the person that's his, I don't know if it's his natural mother or his mother that raised him, actually always was very upset and indicating that she felt that all the individuals in the car were involved as well, because supposedly before he left and got in the car with these individuals, he had $4,000. And that was all taken. And then when he get to the hospital, it was only $200 or $300. And Mr. Carter said, well, he had wanted me to have it because, I'm his friend. And so all this stuff starts, and there was a big argument at the hospital about was there an actual involvement that they were all set him up to get money and so forth. I'm not belaboring that point that there wasn't somebody else killed or somebody that's dead. We're here taking responsibility for what happened. But there's just certain things that I think my client wanted me to just allude to in terms of what happened on this night in question. And as Mr. Body said, and as I think pretrial has said, or probation, he has no real record. He's 22 years of age. One thing I do really want to make sure is that he gets proper credit. Now, he was originally, and this was, I don't know whether this would have come up at trial or not. This was not a flight situation. His mother's here today. He was sent prior to this happening, and I told Mr. Bhatti about this. His home was actually shot up by some other individuals. In fact, that individual was charged, arrested, and convicted here in Fulton County months ago for that. And so she felt it was best. She had said to Nebraska to be with his grandfather. So it wasn't a flight situation, although the U.S. Marshals had to go get him and all that stuff. But that's why he was there. He was there arrested in Nebraska on December 6, 2019, and has remained in continuous custody since then. He got here in Fulton County on December 14th, 2019. And here we are today. He's been in continuous custody. We're coming up on about 2 years and I think 10 months, somewhere in there. I just want to make sure he gets the proper credit for that time.
Sure.
I've expressed to him, we've gone over this case several times about the plea and so forth and the things. I've made it very clear to him that he was facing a life without parole or a life plus 70 years, considering the other charges that he had. He's been pretty remorseful about it. He understands he made a mistake, but he's here to accept responsibility. His mother's here today. I don't know if she wants to say anything. She's been very supportive of him. She's been with him the entire time. It's been hard on her to seeing her son have to go through this. But we would ask that you accept the plea as negotiated, give him the proper credit that he's entitled to. We did talk about, and I'd said I would ask, but I'm not sure what the court's position would be. One first offender, I know it's a serious situation. The court may not incline to give that. A lot of times people mistake the fact that, oh, if I get first offender, I don't have to do any jail time. I said, no, it doesn't work like that. It's what we used to tell certain defendants. It's kind of like if you got it and you were away for a while, it's been a bad vacation, but you eventually have to, you still have to go to jail for a period of time or prison. So we would ask for that. He's entitled to it, where he's in a position to have it, but we understand that the court is reluctant to do that. And I've explained to him the positives and negatives about that.
Okay. Thank you. I appreciate that. Mr. Abate, I meant to ask, you're dismissing count 7. Is that part of negotiations, or was there an evidentiary reason to dismiss count 7, the criminal damage?
No evidentiary reason. It was just part of the negotiations. And just to comment on the first offender, I don't believe the defendant would be eligible because he's pleading guilty to count 2, which is the felony murder, which vacates by operation of law. I understand, but I think that makes him ineligible.
Okay.
For, the First Offender Act.
All right. I think the legal debate is moot either way, but I agree with you. Mr. Warner, you've heard people talking about you. You've been very quiet other than answering the questions, which you needed to do. Is there anything you want to add? You have a right to be heard if there's anything you want to add, but you don't have to say anything at all.
I don't want to say that.
Okay. Mr. Warner, I find that there is a factual basis for your plea. It sounds like we won't ever know which gun fired the fatal shot. Legally, it doesn't really matter. You've admitted you were there. It sounds like the facts are there were several guns that were fired. And the law is, and I'm confident Mr. Katz has told you about this more than you wanted to hear. If you're in on a scheme, you're on the hook for the scheme, whatever the outcome may be. And so God might know that it was a bullet from Mr. Brown's gun that hit Mr. Bryant. But if you were part of the crew that was shooting at the car, all three of the shooters are criminally liable for the murder of Mr. Bryant. And I share that with you not to say it's worse or not as bad, just to help you understand the law that I'd tell the jury. The jury would not have to find definitively that the bullet that killed Mr. Bryant, I don't know if it was ever recovered. It may have been a through and through shot. Sometimes the bullet's recovered. Sometimes it's so deformed that the experts can't say it came from a Glock or it came from this Smith & Wesson. But the jury wouldn't have to work through that. I would tell them that if they believed that there was evidence beyond a reasonable doubt that you were part of this group that was shooting at the car, it didn't matter if you hit one person or fortunately all four didn't get hit. You'd be just as liable as the person who was holding the gun from which the murdering bullet came. So I do find there's a factual basis. I also find that your plea is knowing and voluntary. Voluntary means no one is forcing you to take this plea. You've clearly thought about it a lot. In fact, you've kind of gone back and forth a couple times, which is entirely understandable because there has never been a discussion about a small number. When we talk about going to trial, if you're found guilty, your best option is life plus 5. Best option is life plus 5. As bad as it could get would be life without parole. That's a legal sentence for what you're charged with. So if a jury found you guilty of everything, it could be not a number you can count. It would just be you're in custody until you expire. So everything is big and unpleasant, and I get that. But I need you to tell me that where you are right now with this plea is something that you've decided to do after you had a chance to consult with Mr. Katz and your mother and anyone else whose advice you might rely on.
Yeah.
Yes, sir.
Yes?
Yeah.
Okay. I also find that the plea is knowing, meaning if you had questions, I've watched you consult with Mr. Katz. He's explained things to you. So I will accept your plea. I'm going to follow the negotiated resolution. I see reasons why the state has agreed to reduce the murder count and get you out from underneath that life sentence. I also see why the state didn't say 10 years or something lower than what they did, because it's a murder. Someone is dead, and it was intentional in the sense that the gun didn't accidentally go off and the guns were intentionally pointed at the car in which Mr. Bryant sat. I will sentence you as to count 1, which has been reduced to voluntary manslaughter, to 20 years to serve. Count 2 is vacated by operation of law. 3 merges into 1. Counts 4, 5, and 6. 4, 5, and 6 will all be 5 years to serve. They'll run concurrently with each other, but consecutive to count 1. Count 7 has been dismissed, and count 8 has to be 5 years, has to be consecutive to all other counts. So it will run consecutive to count 4, which gets you to 20 plus 5 plus 5, which is 30 years to serve. Importantly, I will include on the final disposition that you are to receive credit for time served since December 6th of 2019. So you are fast approaching 3 of those 30 years. Also importantly, as Mr. Abate noted, these are all parolable offenses. You have no criminal history. So while these are serious offenses and you'll move kind of far up the grid in terms of when they might think about parole, you don't have a criminal history that will make it more complicated for you. So you will certainly be eligible for parole. Whether you get it is not a decision I get to make, or Mr. Katz or Mr. Abate. The last thing, and I'm not sentencing you as a first offender. I understand the request. I don't know if legally you're eligible for it because of the felony murder count, but I'm not stuck on that. This isn't the kind of crime that I think first offender is appropriate for. Last thing, your indictment right now exists in electronic format, and I need your permission, Mr. Warner, to sign it indicating your guilty plea. Is it all right if my staff signs the indictment electronically for you?
Yes.
Mr. Katz
That's fine, Judge.
and Mr. Abate.
Yes, Your Honor.
We'll do that. Anything else, Mr. Abate?
Nothing further from the state, Your Honor.
Mr. Katz, anything else?
Judge, I guess Mr. Bhatti will provide the no pros for the count 7.
It'll be on the indictment. It'll be stamped in there and it'll be something that I sign. He's made the oral motion. And so I'll sign something on the indictment that dismisses count 7. So there'll be nothing remaining of this case. If Mr. Warner has no other business in Fulton County, then shortly he'll be transferred to the custody of the Department of Corrections. I want to thank you, Mr. Katz, for your persistence in this case. You were clear from the beginning that you believed it was in your client's best interest to resolve it in this way rather than roll some fairly large dice at trial. You were more than capable to represent him very effectively at trial if that's where it went, but your judgment was that that wouldn't be the best outcome for your client. And Mr. Warner, I also want to thank your mother for being here for you and for the legal team throughout. It's important to have that kind of resource because that doesn't go away after today. You're not going to see a whole lot more of Mr. Katz. He has served you well, but mom is there always. So thank you, everyone.
Thank you, Judge.
Thanks, Judge.
Thank you, Ms. Harvey and Ms. Rivers.
Can I get a hold of my mom, please?
I don't have a problem with that, but that is up to Deputy Gordon. If he is okay with that. Okay.
Thank you, Judge. Have a good day.
Yep, you guys have a good weekend.
Have a good weekend, Judge. Thank you.